The Supreme Court has deferred hearing for tomorrow in the AGR case. The court will continue analysing the financial details of telecom companies currently under bankruptcy and determine whether they are faking bankruptcy in order to avoid paying AGR dues worth over rupees 40,000 crore rupees. A three-judge bench led by Justice Arun Mishra observed that they were extremely worried that all AGR dues will be wiped out in the IBC process. Justice Arun Mishra said that after the spectrum sale, the new user may deny payment of pending demands against the said spectrum. The bench observed that spectrum trade is different from spectrum sale under the IBC and nobody can use spectrum without paying past dues. The court asked whether liabilities can be wound up under the guise of selling spectrum under the Insolvency and Bankruptcy Code and likened the situation to the telecom companies taking a ride without paying for the horse. The top court has sought details of all spectrum sharing agreements by telecom companies, while the DoT has been asked to submit details of spectrum allocated to Reliance Communications and Aircel since 1999. The court also asked whether Aircel was trying to sell spectrum under the IBC. It also wanted to know what Aircel had got to do with resolution proceedings regarding AGR dues which were not paid till now. The court also wanted to know that how many dues have been paid till now and what's the amount which is left. Also, Aircel spectrum is being used by Bharti Airtel. That is something which was informed to the court at that point of time, after which the Solicitor General was asked to answer that what was the extent of spectrum which was used by Bharti Airtel. On the other hand, Bharti Airtel had submitted that they have already paid all dues related to spectrum trading, which amounts to 18,000 crores of AGR dues. Senior lawyer Ravi Kadam, appearing for Aircel's monitoring committee, submitted that there were 8 spectrum trade agreements with Airtel and Hexacom since April 2016 and a joint representation was given to DoT, after which a nod was taken for spectrum sale and demand was raised for dues. The top court asked Aircel that when was the trading agreement entered into, to which Aircel's monitoring committee had replied that from April 2016 there were 8 instances of spectrum trade with Bharti Airtel and DoT had given nod to spectrum sale and had raised demand for dues. The court had also questioned what was the amount of Aircel's AGR dues which will be paid, to which the monitoring committee answered that only a fraction of AGR dues will be paid, which will be less than 1% of the total demand. The top court verdict is still awaited on the timeline of payment of AGR dues by various telecom companies, a verdict eagerly awaited by the telecom and the banking sector. The monitoring committee for Aircel had also submitted today that right to use spectrum is an intangible asset which is covered under law and had said that all companies had paid little by little, but it does not mean that these are subsequent dues. It also said that right to use an intangible asset is covered under the Insolvency and Bankruptcy Code and the same cannot be denied by any court of law.